Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the Phia Group.
Hello, and welcome everyone to our latest episode of the Empowering Plans Podcast. My name is Nick Bonds. I'll be one of your hosts today, along with my intrepid partner, Bryan Dunton. Say hi, Bryan.
Hi, everyone. Nice to be here.
We have today kind of a bevy of Supreme Court decisions. Full disclosure, we are recording this on Friday, June 27th, and we had anticipated only giving our expectations on at least one of these cases, but we got kind of a big drop of opinions out of SCOTUS earlier today, and we kind of took a minute to digest all of these a bit and put together some of our thoughts. So we've got an emergency breaking response here on a couple of these cases. But before we get to the brand new ones, we do have a case that was announced a little bit earlier in the Supreme Court's term here that we've had a little bit more time to kind of dive into their opinion on. And Bryan, you've kind of done a lot of that digging here. The US v. Scrimetti case. Do you want to jump in on that one?
Yeah, absolutely. So US v. Scrimetti came out last week on the 20th. That's when the court decided it. That had to deal with a Tennessee law called SB 1, which prohibits medical providers from administering puberty blockers, hormones, or surgeries specifically to minors, but only when the purpose is to enable a minor to identify with or live as a gender inconsistent with their sex. It also references encouraging minors to appreciate their sex assigned at birth. And importantly, these same treatments would be allowed for minors under SB 1 if prescribed for another condition. So early onset of puberty, physical injury, things of that nature, they could still get these medications, just when it's for a gender dysphoria diagnosis, they wouldn't be able to. So the court really took great pains to analyze this. The arguments were pretty detailed. There was a lot of information that was provided to them, and they're pretty split in terms of their decision here, very fragmented on the opinion. Obviously, there was the majority opinion, but there were several detailed concurrences and two dissents, Justice Sotomayor's being probably the longest out of the two. The majority ended up stating...
That's a very fragmented opinion from what we've seen. Like, it wasn't just a straightforward 6-3 or 5-4. I think it does kind of show just how thorny this issue can be, that so many members of the court wanted to write their own opinions.
Yeah, it does. So really what the court was trying to determine based on the appellate court decision that was appealed is what level of scrutiny was meant to apply here. And the lower court had held that it was rational basis, which is the lowest level of review that's assigned to constitutional law matters.
Just for the non-lawyers out there that may be listening, the standard of review you'll typically see at the Supreme Court, there's three levels, like Bryan was saying. Generally, the lowest level of review is rational basis, which essentially just means the law is rationally related to a legitimate government interest. There's the intermediate level of scrutiny that's a little higher above that, and then there's strict scrutiny, which is typically reserved for situations where the regulation or the government action in question is basically potentially impinging on a distinct protected right or a distinct protected class of individuals. And here it seems like the majority opinion really took pains to try to avoid having to apply strict scrutiny and instead applied the lowest standard of review, like you mentioned, which is the rational basis review.
Yeah, that's right. So what the court said first was that this law was not tied to the basis of sex or transgender status. Instead, it says it's tied to medical diagnosis, or technically indication of a medical diagnosis. And because of that, it wasn't entitled to a heightened level of scrutiny like intermediate scrutiny, which is what the plaintiffs were initially arguing for. So that was the first thing that they settled, that it receives that lower level of scrutiny, the rational basis scrutiny. And then they analyzed whether it would survive that or not. And under their rationale, they feel that it does satisfy that. They referenced a few different things in their justification for doing so. They suggested that the state has a legitimate interest in protecting minors from the risks of irreversible medical procedures or interventions, and there was some discussion of that in the arguments about how some of these procedures are in fact irreversible, or at least some of the side effects for receiving treatments can be. There's a documented medical uncertainty in the area, even though, as Justice Sotomayor kind of referenced in her dissent, that all the major medical professional associations in America have a pretty strong consensus on this. There's been some movement in some of the European countries as recently as in the last couple of months, based on concerns they have about the underlying evidentiary standards and studies that have been done in the other direction on this. On top of that, the law's classifications are rationally related to achieving the objective that they laid out. So in the court's opinion, it really just satisfies that really, really low level of scrutiny that's been applied here.
So that was sort of how the court got to their opinion. And then it felt like the other big thing that the majority opinion was trying to get around here was the court's prior decision in Bostock. Effectively, they were trying to distinguish from Bostock here, trying to say that, well, they took great pains to distinguish themselves from Bostock. Maybe you can clarify that a little bit for me, how they were able to do that.
Sure. So they said that Bostock doesn't apply here, and they basically relied on the fact that Bostock was kind of determined primarily based on the because of sex statutory language that existed within Title VII of the Civil Rights Act. And that doesn't exist under the Equal Protection Clause in the 14th Amendment, and they felt that it would be improper to sort of impute that understanding of what because of sex means into the 14th Amendment.
Yeah, so they sort of threw up a wall here between interpreting the basis of sex under Title VII versus equal protection arguments,
Right.
Which I think that alone will probably have some downstream implications for how Bostock is interpreted and applied going forward, this case aside. But so what would you say, Bryan, is the big takeaway from a self-funded plan perspective in wake of this Supreme Court decision?
I would say that in terms of constitutional law, obviously, there's no longer this barrier to putting limitations on treatment for minors for gender-affirming care. However, there are still concerns under the Mental Health Parity Act, Section 1557 of the ACA, and Title VII of the Civil Rights Act. So exclusions and limitations may still run afoul of these even after the Scrimeti decision from last week. Really important to note that this case dealt with state law. So there is still other good law on the books, like Cadell v. Folwell from last year out of the Fourth Circuit. That held that health plans excluding gender-affirming care while covering that same type of care for other uses did violate the Equal Protection Clause, and they applied intermediate scrutiny there. So I think from a plan perspective, they really need to focus on using proper medical necessity, experimental investigational provisions, rather than relying on an outright exclusion or limitation. It kind of skirts the compliance concerns that otherwise would still exist.
Yeah, I think we would all agree that plans shouldn't run too far or too fast with this decision to implement new restrictions around gender-affirming care, implement new express limitations around gender-affirming care for minors under their plans. But they also definitely need to be mindful of the jurisdictions that they're in and the Supreme Court, the circuit court decisions and the state laws that may implicate their plan designs too.
Sure.
All right, well, thank you, Bryan. The other two big cases, like I said, we just got these decisions announced earlier today. It's kind of a red letter day up on Capitol Hill in front of the Supreme Court right now. The first of these is the case of Trump v. Casa. This case is essentially a response to the presidential executive order that was revamping interpretation of the 14th Amendment citizenship clause, Effectively, the executive order was denying birthright citizenship to children whose parents were undocumented or who were present in the United States temporarily. That sort of really walked back prior interpretations of how birthright citizenship worked in the United States. Going back to the 1890s, the Supreme Court had prior decisions basically saying that anybody who is born in the United States is subject to the jurisdiction of the United States and is therefore a U.S. citizen, regardless of their parents' citizenship status. This case didn't specifically weigh in on that application of the 14th Amendment, but what it did look at was the mechanism being used to push back against that executive order. So effectively here, multiple plaintiffs brought lawsuits against the federal government's enforcement of that executive order, and multiple district courts in various jurisdictions across the country issued nationwide or global injunctions against enforcement. And the Trump administration was pushing back against that and seeking relief, basically trying to push back against the ability of a single judge in a single district court to issue such a sweeping block on any enforcement actions. Here, effectively, SCOTUS ruled that universal injunctions likely exceed the equitable authority Congress has given to federal courts. So effectively, under this new Supreme Court case, the ability of a single judge in a single case to issue an injunction is much, much more limited. I think it's very unlikely that we're going to see nationwide injunctions going forward. Effectively, the only situation that the Supreme Court has said a broader injunction could be issued is if there is a certified class action lawsuit brought. And even then, the injunction has to be limited to the members of that established class. So this really does kind of completely overhaul the way injunctive relief can be sought and how it's going to be sought by plaintiffs going forward. I think we'll see we'll see kind of a variety of impacts in the healthcare space and the employment law space. We'll see a splintering effectively of how these federal regulations are enforced, because they're going to be enjoined in various jurisdictions in kind of a more patchwork fashion across the country. So you may have courts in certain jurisdictions that do issue injunctions that only apply to the members who have standing in that case, but it's still going to remain enforceable in the rest of the country. So it's probably going to trigger a much, much broader volley of lawsuits against future enforcement actions by the federal government. And it's also going to really make understanding when and where those enforcement actions need to be complied with just harder to digest. We're going to have kind of a kaleidoscope effect on both ends, I think. So the impact of that one is going to be kind of felt going forward in a variety of ways. We'll have to see kind of what that does to the future of healthcare litigation going forward.
I'm also kind of curious too, I think, whether class actions themselves will see an increase in those, at least attempting to be certified as a class when plaintiffs bring their cases forward.
It definitely puts a big weight on the gas pedal of class action litigation, right? If you're trying to seek broader injunctive relief, you'll have to have a class action effectively. So yep. I don't know, keep an eye on your inbox. You may get more of those annoying emails asking you to join a class action, but
and yeah, it's
wild. It's going to completely change. I think I think it's going to take the industry some time to adjust their practice and their strategy and tactics in these cases. If they can no longer ask a judge to bring a nationwide injunction, it's going to make every single case in ways more impactful for the people that are a party to it and less impactful for the rest of the country. But it also just means it's going to be a lot more work to bring broader relief against any type of, federal government regulation for any party going forward. So yeah, big change to the landscape there. The next case, I think, is kind of a relief because it's actually shaking up the landscape considerably less than we were afraid it might. I'm referring to the case now of Kennedy v. Braidwood Management, the case formerly known as Braidwood Management v. Becerra. I've been harping on this in some of my calls with clients, but this case has been going on since about 2022, back when Javier Becerra was our HHS secretary. With the Trump administration now, of course, we have Secretary Kennedy at HHS, hence the name change. But fundamentally, the Kennedy v. Braidwood management case was a lawsuit brought by a group of conservative Christian employers who sponsored a self-funded employer plan. And they were pushing back against the preventive care mandate. They were also arguing a few other things under the Religious Freedom Restoration Act, basically that having to cover prophylactic treatments, PrEP treatments for HIV and AIDS violated their religious freedoms. The case, when it made it up to the Supreme Court, was much narrower than that. It was looking specifically at the ACA's preventive care mandate and the U.S. Preventive Services Task Force. That's one of the bodies in charge with issuing the guidance and the services that are considered preventive and therefore have to be covered by plans at 100% when received in network, which is the fundamental purpose of the preventive care mandate. Here, the plaintiffs were effectively arguing that the members that make up the USPSTF were not appointed constitutionally. Effectively, they were saying that the amount of power they wielded in dictating the preventive care that has to be covered by insurers in this country rendered them principal officers of the United States, which is a very wonkish term under the Appointments Clause of the U.S. Constitution. But effectively, to be appointed a principal officer, typically you have to be appointed by the President of the United States, subject to the advice and consent of the U.S. Senate. And since none of the members of the USPSTF were approved by the Senate, the plaintiffs in this case are arguing that every recommendation the USPSTF has made since 2010, when this part of the Affordable Care Act was put into place, that all of that is invalid and can't be enforced. And it would effectively throw out a huge number of services that are currently required to be covered by health plans on a first dollar basis. And it would completely upend how preventive care is covered in this country. The federal government, you might be surprised that the Trump administration would continue to defend this case, especially since one of Trump's big pushes in his first administration was to repeal and replace the Affordable Care Act. And this is one of the big fundamental pillars remaining from the Affordable Care Act. But actually, in kind of an odd way, the arguments that the federal government was making to assert that these are not principal officers of the United States actually expands the authority of the HHS secretary and therefore of the executive branch. So effectively, what the HHS was arguing in this case, or what the defendants, the federal government, were arguing in this case, is that these are not principal officers, but these are inferior officers. Inferior officers under the Appointments Clause and under the Constitution, they're effectively appointed by department heads, so by the Secretary of State. And the federal government was arguing that the Secretary of State has the authority to appoint and, more importantly, to fire the members of the USPSTF, and has discretion over saying when their recommendations will actually become effective and be enforced, and could effectively veto recommendations from the USPSTF going forward, which typically the HHS secretary has not done. But here, the Supreme Court effectively sided with the federal government and agreed that the Secretary of HHS does have that authority over appointing and firing members of this task force, and that the Secretary of HHS has pretty broad discretion over how those recommendations are actually implemented and enforced. So because of that, these members didn't need to be appointed by the president and confirmed by the Senate. It basically kept the USPSTF in place and all of the recommendations the USPSTF has been making in place. But that does also mean that the executive branch is going to have a bit more muscle in the area of preventive care going forward. They're going to have a little bit more weight to throw around when it comes to determining what constitutes preventive care and what has to be covered under plans subject to the ACA's preventive care mandate. And we've already seen that Secretary Kennedy is not afraid to fire every single member of a task force like the USPSTF and appoint people he prefers, much like he just did with ACIP, one of the other bodies that grants these, that gives these preventive services recommendations. So this is one that I think there's a momentary sigh of relief that for now, at least, the preventive task services the Preventive Services Task Force recommendations have not been instantly thrown out. That would have been, I think, a pretty seismic bomb to the heart of healthcare in this country. But it does mean that future executive branches, whoever they may be, are going to have that much more power over sculpting and defining preventive care and how that has to be covered by group health plans going forward.
I think it lends a lot of legitimacy to the preventive task force as well.
Yeah.
Yeah.
Yeah. It really drives home that they are appointed constitutionally, and that their authority, now I think it's going to be much harder to question the preventive care mandate and the entities in charge of determining the benefits that are considered preventive services. It's going to be a lot harder to challenge those on structural grounds. I think the only way people are going to be able to challenge them going forward really is either through new legislation or a significant regulatory action, but they won't be able to get a nationwide injunction anymore. That's for sure. All right. So I know we threw a lot of content out there. These were three pretty big red letter cases out of the Supreme Court. There's a few other big ones that don't impact our industry quite as heavily, at least not directly. But it's a big day for the Supreme Court, a big way to close out their term for 2025. So if you have any questions about how these cases developed or how they might impact self-funded plans going forward, the PGC team here at Phia Group, all of Phia Group, really, we're here to help however we can. Feel free to reach out. And yeah, we're happy to do whatever we can to help keep all of our listeners and all of their health plans on the right track. So thank you, everybody. I guess we'll wrap it up there.